Welcome to our YouTube video series on employment law. My name's Christopher Neufeld of Neufeld Legal. And if you're still struggling after losing your job, this video might be of some assistance to yourself in finding some direction with respect to legal action that you might be able to undertake to pursue some form of remuneration from your former employer. Because even though you might well think that the opportunity to go after your employer at this later date, having already taken what they've offered you, is cut off, especially if you signed off on written documentation such as a release or a settlement agreement. That might not be entirely true. So much of employment law is reflected in the jurisdiction that you are or were working in. And unfortunately, so much of what employment lawyers do is they generalize. And they operate under what seems to be the most standardized system. So if you're in the largest province in your country or the largest state, oftentimes that's where the structure of employment arrangements, specifically termination and severance arrangements, emanate out of. And then employers, out of a sake of efficiency, and employment lawyers that represent those employers simply operate on those systems. And all too often, they fail to address the specifics of the jurisdiction, meaning the place where you've been working. And it can be significantly different in many aspects from place to place. And because of that, certain jurisdictions do provide more advantageous protections to employees that even the employers and their employment lawyers don't readily recognize or are not out there promoting. Because many employers take advantage of the termination and severance pay situation and lowball their outgoing employees. Those employers are not going to be providing them with any further financial benefit. And if they're not going to be providing any financial benefit, they don't want to give them lots of money. They want to give them the minimum amount of money that they can. And as such, they lowball and they try to use that in the court system and the costs of going to court to their advantage. So that is why all too many employees end up struggling afterwards, because they fall into the deceptive trap of their former employers in taking packages and signing off on paperwork that they at least believe is cutting them off afterwards. But the fact of the matter is that, especially as I see in my own work here in the province of Alberta, that there are opportunities that the employers and the employment lawyers have all too often overlooked. They might well be aware of it, but they've protected themselves and they've insulated themselves with confidentialities, non-disclosure agreements, settlement agreements, in an attempt to protect themselves. But those protections are only limited, because underlying everything else, in most places there are statutes set up by the government which provides minimums. And minimums are not just the basic wage. There are far more minimums and requirements of employers that are out there. And you have to understand what those requirements are, how the methodology for payroll actually works, how the methodology for various types of leave and restoration of employment work, and all the other protections that exist in employment statutes. And by having this proper understanding specific to your own scenario and your own set of facts, there are oftentimes opportunities to still recover monies from your former employer, especially when the law says that those monies have been properly earned. You've earned, let's say, X dollars. But because of the structure that was being paid out, you might only have been paid out 95% of X, because the structure that the employer is using might well be based on another jurisdiction's employment standards laws. And your jurisdiction might have a higher standard or a different set of calculations. And when you do the calculations correctly, you come out with a different number. Take, for example, Canada. When you look at the different employment standards legislation across the country, there are particularities that differentiate one from the other. Nevertheless, all too often, the employers default to the payroll software and the systems that emanate out of the province of Ontario. And that's because most of the province, the largest number of people are in Ontario. Software is developed in Ontario, training is done in Ontario, and then they push it out. And the smaller the province, the decision is made, well, we're not going to make our own software, we're going to defer to Ontario. Even though the law doesn't defer to Ontario, the system of the employers defers to it. And especially when you're looking at these larger corporations that are multi-jurisdictional but are headquartered in Ontario, they defer to Ontario, and that's entirely inappropriate. So what happens is employees get underpaid. And when you get underpaid, it creates vulnerabilities to the employer. We're not just talking about termination of severance payments being underpaid. We're talking about past wages while you were working, earned money that was miscalculated, and the law says that the correct calculation is money that you are due and owing. And when you have those kind of situations, that is when you have the basis for legal recourse as against your former employer. Yes, it's challenging, and naturally your former employer is going to say, well, we paid you more than enough, we're going to deal with it. The question is, did they in fact do that? They might not well have done that. And you have to actually assess the entirety of the situation. What's the exposure of your employer? What's the vulnerabilities? What is the lawyer that you're going to work with see as the ways to challenge them? How do you go about challenging them? How do you go about protecting yourself? And how does this process get taken care of so that you have the right lawyer is confident in their position, can get paid, and not necessarily confident in the position as to getting paid from you, but ultimately succeeding with the case so as to get paid ultimately from the employer's pocketbook. Because if there's something improper, it's adverse to statute, ultimately it needs to be coming down to the employer to pay for their transgression. It shouldn't be the employee who got shafted because the employer failed to follow through on statute, failed to follow through on the law. That is not where it stands. And case precedent suggests that also, that where the employer fails, where the employer, whether knowingly or unknowingly, failed to remit what was due to the employee. If the employee then, or being the former employer, then goes and pursues the employer for what was justifiably theirs, why should that employee have to then pay thousands upon thousands of dollars to get just the money that they were rightfully owed in the first place? And why should the employer be hiding behind other legal technicalities? That is a challenge that you're faced with. With the right lawyer, with the right set of facts, having worked for a long period of time especially, you can challenge your former employer in these situations. But it's so heavily fact-driven, and it's so much depending upon an understanding of the law and the statute that applies to your previous employment. And if these things line up, and you've got the right lawyer to work with, on that basis, there are opportunities to deal with your former employer to get money that you have oftentimes rightfully earned and are deserving of, and pursue that from your former employer. So that if you're financially struggling right now, don't simply sit back and hope that something will happen. Yes, you've got to continue looking for a new job. Yes, you've got to figure out what you're doing next. But if there's money that remains available to yourself from your former employer, and if you've earned it in some capacity, you should very much be talking to and assessing the situation with a knowledgeable employment lawyer to see if there are avenues by which you can collect upon that money. Because if it's rightfully earned, the law is on your side. But you're not going to find this out unless you pursue it, you look into it, and you realize that there might not be anything there. But the truth be told, all too often, given the way that I have seen how employers structure stuff, they lowball, they fail to address stuff, and they know full well that most of the time employees don't properly assess the situation. And even employment lawyers for employees who understand that it's very expensive proceeding in certain manners, while not in other manners, do not pursue it aggressively and adequately. And that's something that we have seen is being underappreciated and not being taken care of. But if you're willing to look into it, and you're going to a lawyer who's willing to look into it and to potentially pursue it, then you should pursue it and find out where you can come out of it. And hopefully that's of some benefit to you if you are currently struggling after having lost your job and finding a way to move forward and to pursue avenues that are available to yourself. Because remember, you put in the time, oftentimes years and years and years. And we're talking about money that you rightfully are due because you earned that money. So if you've earned money, you should be able to collect upon that money. And that's what we do. Thank you.